So my name's Jonathan Wenig. I'm a partner in the corporate M&A team at Arnold Bloch Leibler.
And my name is Jeremy Leibler, and the same applies to me. I'm also a Monash graduate.
I'm not.
I haven't been back in a long time, and I was looking forward to reminiscing about the days in the law school. But this place looks completely different, much to your gain and your benefit. You are indeed very lucky to be here at this time, because the facilities are quite amazing. So it's good to be back. And
Any questions? Anyone applying for clerkships this year? That all under control?
All sorted? Well, I think they're due, tomorrow or something, right? So, most of you are in what year? What year are you in your degree? First year, second year?
Third year.
Third year, most of you are in third years. Okay. Good.
How many of you have a sense of what commercial lawyers do? Have none of you seen Suits?
It's exactly like that. Put up your hand if you know what shareholder activism is. Okay. Put up your hand if you had heard the word or the term shareholder activism. Okay, that's good. That's impressive. Put up your hand if you can think of an example in the newspapers that involved shareholder activism. That's asking too much. Oh, there you go. We got one.
There was half a hand up.
Half a hand in the white t-shirt. What was it?
Shareholder class action against false festival.
Against
Against the false festival.
Okay. Yep. Class actions, can be a form of
Can be a tool.
shareholder activism. I'm not actually going to answer the question now, because
That would
we'll do
steal
that.
our own thunder.
Yeah, that might. No other questions? We've got to kill the next 10 minutes, people.
I think you actually will all have heard a little bit about shareholder activism. How many of you remember the Dreamworld tragedy? Yeah? Okay. So one of the most prominent episodes of shareholder activism in our market was in the aftermath of that. The company that ran Dreamworld was savaged by the market, and someone stepped in and said, well, I think we can do a better job, and launched a shareholder activism campaign that was successful. So, sometimes it's about sort of connecting the dots of things that you do hear about and how they then play out in the marketplace.
Anyone shopped at Myer? Oh, it's true.
Probably
No one shops at Myer. Anyone heard of Myer? Well, Myer, has and is, I suppose, in a form, still the subject of a shareholder activism campaign, where Premier Investments, this is a company that acquired just under 10%, has been in a now several year battle with the board after it bought about $100 million worth of shares at $1.15 and saw the share price go down to somewhere in the 30-cent mark at one point. And over the course of 2 AGMs has sought to remove directors or spill the board, particularly the chairman. Not entirely successful as yet, but that's still in play. So shareholder activism, as you'll hear, we're going to go through a particular case study, but it manifests itself now in corporate life in all sorts of different forms. It's not limited to trying to replace a board. Shareholder activism can involve trying to force a company to buy an asset or sell an asset, sack management, hire management, pursue a particular strategic direction. And what we're going to talk about today, in about 13 minutes, what we're going to talk about in 13 minutes is the tools that are at the disposal of the activist and the target board. So to talk a little bit about our practice and why and how shareholder activism is something that's a significant part of our practice, really is, and the term is used in the last 5-10 years a lot as this new invention of activism. But really, activism has been going on for as long as there has been corporate life. It just wasn't called that, but it was really about shareholders being dissatisfied with the status quo and wanting to create value. So one of the reasons why we, just to give you some context before we start the lecture as to how we got involved in this, is our client base has always tended to be a highly entrepreneurial, self-made client base. We act for decision makers. We don't act generally for large bureaucrats or bureaucratic institutions where decision making goes through layers and layers, but rather where we get instructed by the CEO, by the owner, by the founder. And historically, those are the sorts of players that have been natural activists, even if it wasn't called activism as such. So really, when we started seeing this happen in the broader market, and we looked at what's happening in the United States, where activism has actually become an asset class itself. I mean, you can buy units in a fund that is an activist fund in the United States. I mean, you can do so here. There are some listed on the ASX. There's Sandon, there's Thorney. But when we saw in the States the size of it, it is huge, and it's targeting the largest companies. Apple, as an example, has been the target of shareholder activists. We identified that as something that's going to happen in Australia, and that over time has played out, and I think will continue to play out.
And I think the other lens through which you should think about today's session and think about shareholder activism is, through the lens of being law students, sort of trying to make decisions about where you want to develop and apply your own careers. And I think, one of the messages that we hope you'll take from listening to us is that, from the perspective of a law student, often it's difficult to really start to understand, well, what are the types of legal issues that a commercial lawyer thinks about? You sort of tend to have a vague idea what a litigator might do. You seem to have an idea what a barrister might do, but what a commercial lawyer does, or what skills a commercial lawyer might bring to bear, is a little more opaque. And I think one of the things, if you think it through, that you'll get from today's session is you'll see that, a lot of the skills and the tools that we're talking about are, things that someone who wanted to be a barrister would also find attractive. So advocacy, sort of strategic thinking, being sort of acutely and intimately aware of the legal details of a matter, of the relevant provisions of the law, of the relevant cases that apply, but then you're sort of not just articulating the conclusion of the case in whichever court it had been decided in, but actually thinking about how to deploy those principles in a live context in order to advantage your client's affairs. So again, it's just something to bear in mind as we listen through the session today.
Yeah, I mean, I think the other point to make is there are any number of ways to be a lawyer. And, I think part of the challenge for you when you're studying law and deciding what you want to do, do you want to go into corporate law, do you want to go into the public service, do you want to go into be an academic, do you want to go to the bar, do you want to not practice law at all? But there's any number of ways to do it. And even within, the narrow confine of being a commercial or a corporate lawyer, choosing any number of law firms, there are different types of lawyers. You've got firms that pride themselves on being pure black letter lawyers. Now, it's actually not entirely fair to say that. Most of the firms will not pride themselves on it. Most of them these days, it's not particularly trendy to talk about yourself as a black letter lawyer, because clients generally are not looking for lawyers that describe themselves simply as black letter lawyers. But many lawyers out there are purely black letter lawyers, where they deal with the law. Client comes, asks a question. What does this contract mean? What does it say? Can I do this? Will I be in breach if I do that? And they give the answer. But unfortunately, they give that answer without a commercial context or the benefit or understanding of the client's particular circumstances. While any successful corporate lawyer needs to have black letter lawyer skills, understand the law, know how to interpret the law, have a sense of how a court might apply the law. Much of our practice is focused on using the law as a vehicle to achieve clients' objectives. And often what that involves, and this is intimately connected in the whole activism space, but what that involves is often it's about measuring risk. It's not about saying to the client, you can't do this, you can do this. It's about saying, this is the risk associated with going down this path. Now let's talk about how that risk weighs up with the potential return and what you're seeking to achieve. Is there a balance or is there an imbalance? How do we use the law as leverage to achieve your objectives? Most of our time is spent navigating those issues with clients, and it is different to to the practice often of a barrister, where much of their work is confined to straight black letter legal interpretation.
And it's different to the role of a uni student too, a law student, where, again, most of your training, which is crucially important in what we do, but most of your training is in looking at the law, looking at the exam question, looking at the essay question, dissecting the law and answering whatever problem it is that's been put in front of you. And I think, that's where the steep learning curve comes in when you start commercial practice, because you have to take all of that and apply it in a sort of challenging environment, but then you have to layer on top of that a whole lot of other sort of skills and lenses through which you're thinking about the issues that are on your desk. Yeah.
So, if you have clients across like a number of different sectors and industries, do you find it difficult to kind of become specialised in whatever that industry might be, when the client's probably got more of a clue about their given industry than like you might happen to cover like many different ones in practice?
Yeah, it's a really good question, and one we talk about a lot. I mean, it is certainly the case that many, maybe even all, of the matters that cross our desk will require deep, specialised expertise in an area of law or in relation to, the particular sector of the market that the client operates in. Our approach to that is to say that the first order task, the most important part of responding to that client's needs, is being an absolutely excellent practitioner, deploying the types of skills that Jeremy just described. That's the first order task. We will, our approach will be to say, listen, we know those things and we know them inside out. And if we need to deep dive into a particular area of the law in order to get to the bottom of it for the purpose of the client, well, we can do that. Our argument to the client, and it's successful because the clients keep coming, our argument to the client is you're better off getting the practitioner who has the skills and mastery of delivering outcomes and is sufficiently smart and sufficiently capable to deep dive and become a subject matter expert, in relation to that area, than necessarily the person who does that particular narrow thing every day. There was a partner at ABL, he's no longer a partner, he's retired, his name was Robert Heathcote. And Robert Heathcote was with the firm for decades, and he started off life in what was predominantly a commercial, sort of a corporate law firm, property firm. He started off life as a commercial litigator. And he would do the commercial litigation that sort of fell off the back of whatever deals the commercial clients of the firm were doing. But Robert was incredibly smart, and sort of 10 years in, the main problems that were confronting Arnold Bloch Leibler clients at that time were planning issues. And Robert became one of Australia's foremost planning lawyers. And 10 years later, there were a series of clients who had, call them white-collar criminal issues, in relation to tax, in relation to other compliance. Robert became one of Australia's foremost white-collar criminal lawyers. And 10 years later, the issues that were confronting our clients were essentially ACCC issues, competition issues, class actions from people affected by alleged breaches of antitrust competition laws. Robert became one of Australia's foremost competition lawyers. So that's the model.
What Jonathan's saying, and he's being modest, more modest than I would be, is that it's actually about being the smartest guy or girl in the room. That's what it's about. And if you apply to ABL, you need to be confident that you can be that person, because the notion of super specialisation, which was very popular amongst many firms 10, 20 years ago, and now all of the large firms are calling themselves generalists, it was popular, and what would happen is, it happens in the medical profession. You go to a neurologist and they will find a problem with your brain. You go to a cardiologist, they will find a problem with your heart, and so on and so on, and it's no different in the law. A client comes to an advisor and wants a holistic solution and review and understanding of their situation. The most important thing is that you can understand their business. I don't need to be a resource expert, a geologist, to be able to steer a client through the sale of their mining business. I'm not, and I don't need to be. We have, basically zero resources expertise, yet we just acted for the administrators of Arium, which is probably Australia's largest corporate collapse for the last several years.
In that sector.
Right? In that sector, yeah. But it's about being, right, the smartest person in the room. And that doesn't mean you have to know everything. It just means you have to know where to find the answers.
Shall we start?
Yeah.
Okay.
I think we've just introduced ourselves.
That's very good. So, I introduce myself now as well. Yeah, I'm Norman Witzep, the Chief Examiner of Corporations Law, and I take the opportunity to formally welcome you back to Monash, or to Monash, so we're really excited about this new partnership that we have with ABL, so what we're trying to do is two things really. We're trying to enrich your study of corporations law with giving you some access to, real life experiences of what it's like to work as a corporate lawyer. And at the same time, we want ABL, to give ABL the opportunity to showcase its, its expertise and its practice to you guys. So apart from Jeremy and Jonathan, we have some HR officers of ABL with us today, and we also have some junior lawyers, and after the...
Admitted as of yesterday.
And after the talk, there'll be an opportunity for you to mingle. There's a few canapes and so on. So there's a social and a networking aspect to the session as well. This session is the first of its kind, but we'll have 4 over the course of the year. You're lucky enough that we have 3 in semester 1 and 1 in semester 2. They're all recorded, so if you miss one, so if you want to later on listen to the 4th one in semester 2, you can do that as well. Hopefully it's all going well. It looks pretty good. So I'll just let you keep going, and
Thank you.
It's yours again, yeah?
Okay, thanks. All right, we'll make a start. So, for this first bit of our session, you'll forgive us. What we want to do is we want to actually sort of assume characters. So, you're going to need to use your imagination here. So, imagine that I am a white male, over the age of 45, with a little bit of grey hair. Now, in the scenario, I think I'd probably be Anglo-Saxon Protestant. I'm not, I'm Jewish, but, you'll have to use your imagination at least for that bit. And if you can construct that image in your mind, you'll have a picture of what your average director of an Australian ASX-listed public company would look like. And that's where we're going to start this discussion. Because Australia is a bit blessed with a very, very healthy stock market, a very, very healthy and developed and sophisticated sort of system and organisation of governance. We have great companies, many, many great companies that are very, very well led. And the things that have enabled us to be well led are what is a relatively small pool of very smart people. Now, they happen to be men, largely. But they're very smart people who have led these companies incredibly well over a long period of time. Been focused on the long-term interests of shareholders. And, they have... they've worked very hard to balance all the considerations that directors need to balance. Strategy and implementation, compliance and governance. And they do a really good job of it. And those people are the ones who, all of a sudden, because of this wave of activism, suddenly find themselves under attack. So, I'm an activist.
Now, what does that mean? What's the difference between being a shareholder activist and simply being an investor? Well, fundamentally, the difference is that I'm not passive. I don't look at companies with analysts, look at the numbers, look at its earnings, look at its prospects, look at its industry and say, yep, I think it's going to be a good investment. I'm going to invest my money, I'm going to invest my fund's money, my investors' money in this company because I think the value of this company will increase. I create value, right? Thus the word activist. I go into companies that I think actually are undervalued, but where I think I know what the problem is, and I set out to, ideally by agreement, but if not by force, require the board to implement whatever strategies I think are key to improving and creating additional shareholder value.
There's an arrogance there, though, isn't there?
There is an arrogance, and that part of it.
I've been running the company for decades, and you come in and you think you know what the problem is.
That's right, and often that's the case because sometimes you need to look at things from the outside rather than from within. It also, if we go back a slide, may or may not occur to you as the activist that a room filled with men who look the same and think the same and talk the same may not be the best way, right, to bring a diversity of views to the boardroom. Now, if I pause, we're being a little bit harsh here because corporate Australia boardrooms are not as bad as this, but they're also not what they should be. So maybe this is what it probably looked like 20 or 30 years ago, and it would look a little bit different today, but we're nowhere near where we need to be, and that's a challenge.
So would you say that activists are passionate about gender diversity, about environmental sustainability, about those
Activists are passionate about making money. But issues like gender diversity, sustainability, can play into that in two different ways. The first is that the studies show very clearly that having diversity around the boardroom table actually is more likely to create value than having a group of people who look the same, think the same, and talk the same sitting around a table. That's number one. But the other avenue, and the other reason why those issues are a tool to activists is because they are hot topics at the moment. And the key with activism is that most of the time an activist, unlike someone that wants to buy the company, they don't acquire control of the company in order to affect change. I, as the activist, will often have a stake of under 5% of that company. And part of my job is to garner support from other shareholders. And there are many funds who consider issues like gender diversity and sustainability key issues. So if I can hook that into my campaign, I'm more likely to attract the support from those other shareholders, which will be critical in me achieving my objectives. The other tool that activists use, and you'll see this in the case study that we're going to start in a minute, reputation. This boardroom that you see contains a pool of independent...
I think you mean this one.
No, even that one, right? Contains a pool of independent directors, right? All of whom will probably know each other, will sit on another board with the other one, and it's very, very incestuous. We're a very small business community. So what that means is that their reputations are paramount because their livelihoods depend on it. They will sit on 2, 3, 4 boards, they will earn significant directors' fees, and they're always looking to the next board appointment. None of them want to be the subject of a campaign by an activist. None of them want to have their reputations questioned in the media. So their reputation, the use of the media, right, are tools in addition to the legal tools that we're going to talk about in a minute that an activist will use.
So the flip side of what Jeremy's saying, and you'll read about this a lot, if you follow what happens in the market, is that there's a huge push for independence, right? We want to have the people running these companies, the directors, want them to be independent. What are they independent of? Well, they're independent of management. They can make clear, objective, considered decisions, right? And so there's this interesting interplay between directors saying, well, we know better, A, we are independent and you're not. And so Jeremy just sort of articulated the first line of attack on that reasoning. The first line of attack is to say, well, you know, A, you may not be better. B, you know, you guys are pretty reliant on your directors' fees, right? You're really just out to cover your own backsides, is a line they'll often say. And then the other line of attack is on the independence itself.
Well, so the issue is, and you know, independence is very popular today. It's also a hot topic as hot as gender diversity, sustainability, which is, you know, boards have to have a majority of independent directors. Well, a lot of activists think that's a load of rubbish. A lot of activists will say, I want directors on the board who have skin in the game. I want directors on the board whose interests are actually aligned with shareholders. When they need to make a decision, they will measure risk based on the impact on shareholder value because they have their own money invested in this company. Otherwise, they're actually incentivised to not do very much. Just sit there, keep their head under the radar and continue to collect that cheque every month. So I think on that note, why don't we move on?
Yep.
We'll run through relatively quickly, just so you're aware of the basic law, so it will be relevant in the case study, but run through the basic legislative toolkit.
Yeah. So most activist campaigns, in one way or another, look at the composition of the board. They don't necessarily go all the way to a proxy fight, but one way or another, what they do is they say, how can we not control, but have a say in the direction, the control of a listed company? So, you know, let me just go back a step, and you know, you've probably covered this in your first few weeks of corpse law, but this is my very helpful brief summary. A company is a legal person. It can do things, it can own things, it can sell things. A company has two bits. It's got a board of directors that basically make all the decisions, and it's got a shareholder meeting. It's got members who own the equity, right, who are ultimately entitled to the benefit of whatever the company produces. But basically, lots of exceptions, members make one decision. And the one decision they make is who gets to be on the board. Okay? So, in covering the basics of how people get to be on a board, so in terms of a listed public company, there are really two ways. One way is that the board of directors can themselves fill a casual vacancy. So the people sitting around that table, you saw in the previous slide, can say, hey, we'd like to bring someone else on to be part of the board. And the other way that people get appointed is they get appointed by members. So anyone on a public company board has to have their appointment reconfirmed at least every 3 years in the general meeting. So they have to go up from retire and put themselves up for re-election if they wish to. But the first piece of the legislative toolkit is that you know, there is this element of control that the shareholder meeting exercises as to who gets to be on the board. If you want to remove someone from the board, it requires a vote of shareholders. If you want to appoint someone to the board, apart from the board appointing their own members, you need a vote of shareholders. So that's the first piece of this puzzle. I think you were going to talk to 249D?
Yes, 249D. So there are two ways that a shareholder can call a meeting to change the board, get rid of the board, add a director, any of the above. One is under 249D, and very simply, a shareholder or shareholders that have 5% or more of a company can force the board to actually call a meeting and put forward the proposed resolutions. Now, the advantage of this approach is, anyone guess what happens if you force the board to call the company, to call the meeting? Well, who pays for it?
The company.
2 points. The other option is 249F, where effectively the shareholder with more than 5% as well can call the meeting themselves, issue the meeting documentation, the notice of meeting, the explanatory memorandum, send it out to shareholders, organise the meeting to be held, organising the registry to be there and count the votes. Anyone think of a potential advantage to that?
Disadvantage is you have to pay, but the advantage is if you're the one calling the meeting, you're the one sending out the notice, what do you control? Yeah, you control the narrative to a degree. You
And
control
this,
the process.
and in a battle for control of the board, that document is, it's a marketing document. I mean, it's a legal document, but it's used as a marketing document. So if I'm an activist and I requisition a meeting, I force the company under 249D, they will ensure that every single inch of that document is justifying their own existence and why they're right and we're wrong, and vice versa if I call the meeting myself. But well, we can just skip this slide. And this slide is, you can also put forward resolutions without calling a meeting if a meeting's being held, but we'll just skip over that for now. The one exception to that is 249P, to the idea that the company, when a meeting is requisitioned, controls the messaging, and that is, if you requisition a meeting, you're entitled to include a 1,000-word statement, right, that the company has to include. And that's your opportunity as the person calling the meeting to get your message out there. Now, 1,000 words is not a lot, and it's going to be buried in a bunch of documents where everything else is, criticising you, yet it is a tool. And there's also a whole bunch of law, which we won't go into now simply because there's not time, around, the grounds upon which a company can refuse to publish that statement, if it's defamatory, if there's something misleading and deceptive in it. But we'll just keep in mind that that's something in the target board's toolkit.
So the next page, I don't know if you've covered this yet, but the next page is something that is a key tool for activists in Australia. And in fact, it's a way in which Australia's legal system for the time being is somewhat unique. So in the United States, for example, they have some similar provisions around, say on pay, but it sort of, the landscape is a little more scattered. So in Australia, every year listed companies must deliver to shareholders a remuneration report that includes details of the basis upon which the employees of the company are remunerated, their remuneration policies, and it has to go to a non-binding vote at the AGM, at the shareholder meeting. And it's a non-binding vote, but because if there is a strike, and a strike is only a 25% negative vote, sorry, not if there's one strike, if there are two consecutive strikes against the REM report, then essentially shareholders get the opportunity to spill the entire board, in other words, kick them all out, and have another meeting at which replacements can get appointed. So you can see why this is a key tool for activists. And, if you read the business pages, you'll see that this is happening on an annual basis. You get to AGM season, and this is a key way in which shareholders wield their power. How they deliver a message to companies that they're not happy with what's going on, sorry.
No, and the point is, and this rams on the point that I made earlier, it's actually a blunt instrument, because you can't actually spill the board unless you have more than 50% support anyway. All you can do with this 25% vote is cause there to be a vote, but ultimately when that vote is held, to replace the board, more than 50% of shareholders voting have to vote. So it's an entirely blunt instrument, and I don't think, there are many cases of first strikes, there are some of second strikes, but I don't think that there is a situation in Australia where a board has actually been spilled.
Although that said, last year, all of the big banks,
They got strikes,
got strikes.
right?
It was a clear message, huge strikes, so 70, 80% votes against.
But notwithstanding the fact that it's a blunt instrument, I can tell you this, directors live in fear. Every year before AGM season, they come shivering and shaking. How can we avoid a strike? What can we do? We have to improve our gender diversity on the board. Oh, but we actually don't really want to. We have to make our remuneration structures look more attractive, right? We have to pay our CEO less, but hold on, we don't really want to either.
Because we'll lose our CEO.
Right. But the point is, they don't want the reputational damage of this strike. And it goes back to that original point, right? And it will be relevant in a minute, which I promise we will get to this case study eventually, where it is all about the use of the law to create leverage. Two strikes is relevant and powerful, even though it's essentially a blunt instrument.
It's non-binding on the company, etc.
Yeah.
Okay. So two cases, sorry, go back to director's duties. So this I assume you will have covered, and this ends up being crucially relevant to any activist play, right? Because it ends up being a discussion about what is in the best interest of the company. And you're making allegations against directors as to whether they have indeed lived up to these standards and duties that you will have already read about in the course of starting to study corporations law. So we wanted to talk briefly about two cases that are really important in this area. The first is Advance Bank. So this is some time ago, this is in the wild 80s. So there was a bank called Advance Bank, and FAI Insurance, which was controlled by a guy by the name of Rodney Adler, subsequently went to jail. But Rodney Adler owned about 10%.
I think it was actually his father.
It was his father, it wasn't Rodney?
No.
Might be right. How old was Rodney?
Family, yeah.
It was the family. So basically, this was a contest for board control. Rodney, FAI Insurances put forward a proposal that all the directors be kicked out and be replaced by the slate of directors recommended by FAI, including both FAI representatives as well as independent directors who they were putting forward. And it ended up being a particularly bitter fight. So the company spent a lot of money advertising, sending mail-outs to shareholders saying, these guys are crooks, these guys don't know what to do with this company, we are much better, defending the reputations of the existing directors. And ultimately what the court found was that that it's not, I'll just read this out, to the extent that directors in a situation of potential conflict of personal interest and corporate duty stray into exaggeration, half-truth, emotional language and misleading statements, the risk they run is that their activity will later be characterised by a court as not bona fide for a purpose of the company, but rather for the primary purpose of their own re-election. And so it stands for the principle, it's a little bit of a wobbly principle, but it stands for the principle that in a board fight of this nature, the company is constrained. The existing board cannot spend corporate funds in order to protect their own backsides, and they can be held to account, to strict account, in order to ensure that the money that they are spending is in the best interests of the company and not in the best interests of the directors themselves.
So this second case, and we'll just go through this quickly because we want to get to the guts of it. But in a sense, there is a case where a judge said something to the effect of, when a board knows that a major shareholder, is proposing to replace it or change it, it's effectively in sort of caretaker mode, and it shouldn't make major decisions that it knows is against the wishes of that major shareholder.
Why the tone?
Have I ever been to court to rely on this case, or frankly, the FIA case? FAI case? No. Would I? Probably not. Yet, it's a tool.
Have you threatened it?
Well, we've simply pointed out that this case exists. And why do I do that as an activist? Because again, the non-executive director club that you saw in that picture, who all know each other, who are all looking for their next gig, the last thing on earth they want to be is accused of somehow breaching their director's duties or acting, in their own interests instead of the interests of the company as a whole. And these cases, even though it's not strong established law, right? When it's written in a letter, and we'll give you an excerpt of a letter that we've sent in the case study in a minute, and a director receives this letter personally with a very gentle and kind suggestion from the activist lawyer that the directors might want to seek their own independent advice, independent from the advice the company is seeking, because their own backside is at risk here.
And by the way, they should pay for it themselves, not through the company.
It sends shivers down their spine. And that impacts how they behave and how they respond.
Although the flip side of that is that if the directors are smart, they can articulate the case for status quo in a way that is an expression of what's in the best interest of the company.
And do.
And they do. And that's how they play it. And they won't just simply say, hey, I'm really great, I'm really smart, you can't possibly kick me out. Instead, what they'll say is, hey, this is what's really working for the company, these are the strategies we've delivered upon.
All right, so just the next one, and again, all in the same theme. Two other things in the toolkit. One is the ability to ask for a copy of effectively the share register. There's two registers. There's the register and there's the beneficial holder register, which is actually who really owns the shares. Now, what is that? All that is you write a letter, you say, can I have a copy of the register? Here's $500, and they have to give it to you. But it's often used as a tool. It's often the first warning shot by an activist to a company. They might have a meeting. We want you to sack the CEO. We want you to buy this business. We want you to do a buyback. We want you to return capital. We want you to pay a dividend. Whatever it is.
Put one of our people on the board.
They tell you to get stuffed. A few days later, you just send a gentle, 5-line letter. Can we please have a copy of your register? Under this section, here's $500.
Jeremy uses the word gentle ironically.
Right.
I don't know if you're getting that.
I was going to ask, does it have the percentage breakdown of the shares held by the
Yes.
Yeah.
Yep, exactly the number of shares held by each shareholder. And there are lots of fun and games around these letters when they can try and resist providing it, or they give you the list, but they give it to you in a form that you have to spend the next 10 years of your life working out how to use, and there are cases all about that and fun and games, but we won't go into that now. So, associations. You can do this?
Fine, happy to. So the other last piece of the toolkit before we get to our case study is that this is a part of the corporations law that you probably won't cover in the subject corporations law. At least I don't believe you do. But Chapter 6 of the corporations law basically governs competition for control in public companies. And this is a gross oversimplification summary, but there's a rule. You can't buy more than 20% of a public company without making a bid for the whole. So that's rule number one. The way that law works is that how many shares you have is sort of broadly construed. It's not just what you own, it's where you control the votes attached to those shares or you control the disposal of those shares. And finally, there's this concept of associates, where parties are acting in concert in relation to the affairs of the company, then for certain purposes associated with Chapter 6, their votes are aggregated. So clearly what can happen, if you're talking about an activist play, is that a group of shareholders get together, or the activist knocks on the door of a few shareholders and says, hey, these guys don't know what they're doing, we're going to kick them out, do you support me? And sometimes where the activist might trip up, so this is a tool that the company might use in response to an activist, is they'll say, well, you, Mr. Activist, only own 2%, but you've knocked on the door of shareholders holding 30%. And all of a sudden, you've created a block, really good, really nice, really big, really powerful, but you've breached Section 606 and you've breached Chapter 6, right? You've gone above that 20% threshold and you haven't complied with one of the exceptions. So this is another, and we'll see the other side of this in a moment when we get to the case study. Okay, Praemium. Praemium is an ASX listed company. It's effectively a software provider for fund management services. It actually is fairly irrelevant to the story. I didn't know Praemium, I didn't know its CEO, but the CEO came to me, someone referred him, and he said, I've got the problem of my life on my hands. I'm the founder of this business, I still own about 4%. I built it, I'm the founder, I drove it. About 5 years ago, the share price was 8 cents, now it's at around 60 cents. And yesterday, the relatively new chairman who'd been in the position for about a year called me into the boardroom, sat me down, put 2 pieces of paper in front of me. He said, this is an ASX announcement on your left that says you've decided to retire, to pursue other objectives. You are the amazing founder of this company, you've achieved so much, you're wonderful, we love you, we part as friends. It's the old we can do this the easy way or the hard way.
Pretty much. And the other ASX announcement is, effective immediately, Michael Hannison is no longer the CEO, which effectively tells the market he's been sacked. So he initially came to me, seeking some advice in relation to, well, what the hell does he do about this? I don't think he'd formed in his head or had thought too much about what he could or should do. So it became very clear from our conversation, though, that this was not really just about his employment. This was about his life. You know, this was the most important thing to him. Most of his wealth was tied up in this company. And he fundamentally disagreed with the direction of the company that the new chairman was taking. He was a, ex-investment banker, management consultant, was a guru in strategy, and effectively they were at loggerheads over the direction of the company.
So maybe I'll just step in there, and forgive me because this was Jeremy's matter, so even though I'm going to try to argue the alternative case, he knows a lot more about it than I do.
Good state of affairs to be in.
So from the chairman's perspective, yes, this guy was the founder. Yes, this guy had done a whole bunch of good things for this company, but this guy was a nutcase. He was impossible. He had terrible dysfunctional relationships with much of his management. He had terrible dysfunctional relationships with almost everyone around the board table. You know, the chairman was the pointy end of that, right? Most of the bashing heads was between the chair and the CEO, but this guy was really difficult. And ultimately, whose job is it in any company to set strategy? It's the board's. And the board had undergone a rigorous, detailed process to assess where the company was at and where its future direction would be. And it had come to a series of not impulsive but carefully thought out decisions. And it had communicated that carefully to management. And Jeremy's client said, no, don't want to do that.
And that's all 100% right. I mean, that was how the board felt. But in all of their planning, in all of their strategy, there was one little thing that they didn't do. They didn't consult with their shareholder base. And, Jonathan's right that often there is an air of arrogance about the activists, but equally as often there is an air of arrogance about the target board. So this was a board
The
that thought
ivory
that
tower
they know best. What do these shareholders matter, right? They only own the company, right? We know best. We're the strategy gurus. What does this CEO know who built the company from scratch? Nothing. And that was their first and fundamental error. So in talking to Michael, I asked him, the first question I asked him was, how much of this company do you own? And it's 4%. And then I said, what do you want? He goes, well, I want my job back, but I want my job back not because I want my X dollars a year that I'm getting. I want my job back because I want to redirect this company on a path that's going to create shareholder value for everyone. So I said, well, who are your friends? Who are your supporters? And he goes, well, I think I've got a lot of supporters. I think we're on the next slide.
Okay.
I think we've got a lot of supporters. So I said, well, go talk to them. But then we had to spend a lot of time talking about what he can say to them. And that goes back to the association point that Jonathan was explaining to you. As soon as he reaches any sort of understanding with another shareholder that has more than 1% of the company, they tip over 5%. And that means it's fine, but they have to lodge a notice to the ASX telling the world that they're working together. So until they were at a point that they wanted the world to know that they were talking together, we had to script for him what he could say and what he couldn't say. He can inquire to them, are they happy with the direction of the company? He could say, would they be supportive if someone were to spill the board? He could ask them if they were supportive of him being reinstated as CEO. But they couldn't reach some sort of understanding as to what they were going to do together. So we navigated him through this process. We talked him through the options about calling a meeting.
John, there's just a question. Sorry, is that a question?
Sure.
When two shareholders are sort of talking, do they have to be in agreement to have to log that notice, or can they just be?
It's a hell of a lot looser.
So
Sorry.
it's any agreement, arrangement, or understanding is what the law says.
But then it also says if you are acting in concert. An agreement, arrangement, or understanding doesn't mean it has to be a written agreement, drafted by lawyers. In a totally different context. The Takeovers panel, for example, has found that if the two people have a pattern of meeting with each other and they use the same lawyer in order to lodge their substantial shareholder notices, the panel will sometimes draw inferences that they're associates even from those sort of slightly circumstantial bits of evidence. So it's a lot looser than that.
So it's very, very broad and you have to be very careful about it. So then we talk about, well, all right, we think we can garner the support from shareholders, we can tell a good story. how do we go about doing this? You've got two options, right? What are the two options to call a meeting? Call it yourself, or force the company to call it. Now, in this case, he was the founder of the company, and his stake was worth, a fair bit of money, but he wasn't cashed up. He hadn't taken money off the table yet. So rather than incur the costs of calling the meeting and renting a hall and everything, he decided to force the company to do so, notwithstanding the fact that it was a disadvantage to him in terms of the messaging. The other thing that we did was we engaged with the media. We started backgrounding the media, the journos that we wanted to cover the story so that they understood our narrative before it all went
just
public.
go back and talk about the share price drop. I mean, so see the circle in that graph. The share price, when it was announced that Michael had been sacked or was leaving, dropped very, very significantly. And the message that delivered to Michael was, well, actually, the market quite liked him, right? The shareholder base was behind him. They wanted him to be involved in the company. So,
Yeah, that's right. But that being said, it was never a slam dunk and it was never in the bag. And the point that I made to him, we talked about strategy, we talked about the legal levers that we can use. But at the end of the day, it's all about the numbers. It's the numbers that count at the end of the day. So what he did was, once we were ready, he found two institutions that had profile: Paradise, one of the largest fund managers in the country, and another sort of private family quasi-institutional group. And the three of them, who collectively held, now I can't remember what it was,
17
about 17, so under the 20% sort of rule, they collectively requisitioned a meeting. Now, they entered into cooperation deed and were effective. They said they were going to requisition this meeting and vote together. Now, they didn't need to do that, but we did it on purpose because this document must be attached to the substantial shareholder notice we lodged with the ASX. And what that does is it sends a message to the company and the market, the support from Paradise wasn't, yeah, I think I'll support you, yeah, I should be okay. It was watertight, it was locked in, it was real, and this was happening, and they were now already locked away. That's 20% of the register that is taken out of the debate, out of the battle.
Let's just talk about the numbers for a second. So, clearly in order to remove a director or in order to appoint a director, you need 50%. But what does 50% really mean? It doesn't necessarily mean 50% of the whole number of shares on issue in the company. It's 50% of those present and voting at the relevant meeting. So, not everybody turns up. Not everybody either turns up to the meeting or sends in a proxy, right? So 20%, even though it sounds like it's a long way from 50, is actually a really powerful statement of the level of support that he had or could expect. So the next thing that we've just flashed up on the screen is the notice that Jeremy with Michael ended up sending to the company, right? It's a notice of intention to move a resolution for removal of the directors of Praemium, and it was signed by shareholders holding 5%, and in fact, it probably was signed by shareholders holding 17 or 18%. And they also put forward at the same meeting, in the same notice, they put forward their own slate of
directors. So we were spilling the entire board, which is actually quite unusual. We were saying they all need to go. And by the way, I mean, there were a whole lot of negotiations that in the lead up to that where they actually offered to sort of, some of them resign, to appoint some of our nominees, but our guy formed the view that after he'd been sacked in that way, he could not work with them anymore. They all had to go. And he was very pig-headed about that. Once the notice of meeting was out, it was the coverage was quite explosive. There was this was not a large market cap company, but I think the nature of it, the sacking of a CEO, all of the drama, resulted in a huge amount of media coverage and columnists. I think it was the Fin was against us and the Oz was supportive, or the other way around. I can't remember. The other way around. But I'll read you a quote that I gave, because it will give you a flavour of how vicious some of the correspondence and the coverage was. So this was a quote that I gave, which was, this is the quote from the paper saying that the board was basically, its defence was corporate governance. We can't have the CEO who was sat come up and control the board, even though the directors we were nominating were all independent directors. So I said, this is the same board that recklessly disregarded the will of its shareholders and terminated the CEO without cause or consultation. Unfortunately, the incumbent board has learnt a critical lesson about corporate governance. You can't sack a premiership coach for no reason and expect the support of your fan base, no matter how you justify it after the fact. The proposed directors have been nominated by Paradise, Australian Ethical and Abercrombie Group. Any attack on their independence is blunt and unimaginative. The proposed directors are professional, committed to implementing a higher standard of corporate governance. Now, you guys don't know me, but let's just say I'm not the sportiest person in town. Okay? So a sporting analogy doesn't come naturally to me. Why use a sporting analogy?
It's popular with the general people.
And it's going to be understood immediately by the general people.
And the journos love it. They love one-liners. So everything that we did, all of our messaging was crafted in a way that would have, appeal and get coverage, because this is pressure, right, on that incestuous non-executive director pool, right, who by this stage are thinking, how the hell did I get myself into this and how do I get out? Back to, if we go back, so you're back onto it. So if you have a look at that, that is an excerpt of a letter that we sent to the directors. Each director individually received this letter, and it deals with the caretaker mode and duty of directors that we talked about before we talk about the advanced bank case. So this is just an example of how we wrote to them. And I can tell you, I know for a fact that the directors found this very, very confronting. Some of them did go off and seek independent advice at their own expense, right? They were nervous, and they were nervous we were going to come out with them. And apart from anything, what that did was it kept them a little bit honest, because there are a whole lot of games a target board can play on, do we accept the notice? Do we argue that it's invalid for this reason? There's heaps of case law, mainly from the 80s, about that. The reason why there are all these cases from the 80s and not now is because the corporate environment has changed. Back then, a board could get away with relying on some legal technicality to refuse a major shareholder trying to requisition a meeting. Now, the board would come under enormous criticism for wasting shareholder money on the legal dispute over a technicality when fundamentally the law is clear that a shareholder is entitled to call this meeting.
But also,
That keeps them honest.
compared to the 80s, which was before the era of compulsory superannuation, we now have a market that is basically owned by Australian working people, right? Because there's compulsory superannuation. Superannuation funds are a huge part of the market. And so that dynamic has really changed in the background. You can't get away with what you used to be able to get away with because the makeup of your shareholder base has changed fundamentally too. And maybe just before Jeremy sort of takes you through the conclusion to the saga, one sort of editorial comment. And that is to say that I hope the message you take away from listening to this case study is more empowering than intimidating. And what I mean by that is, we've talked to you about a few legal tools that, the truth is, the legal tools are pretty easy to understand. The two cases that we took you through in very, very briefly, are interesting, but they will be entirely within your grasp. And the rest of this stuff, the strategy stuff, the use of the sporting analogy in order to persuade, whoever it is that your audience is, those sort of soft skills of persuading and influencing people are things that all of you bring to your everyday lives. And what Jeremy and I often say to clerks, to grads, who are working in our team is that, the sooner you actually realise that, working in a law firm and the way in which you get things done or you persuade or influence people within the environs of a law firm is not actually all that different to how it is at high school or at university or in any other, area of life. No, it's different in a whole lot of ways. But the sooner people sort of work out a way to sort of marshal those soft skills and deploy them in their own careers, the more rapidly they develop as,
fully capable commercial lawyers. Okay. So what happened, there was a whole bunch of correspondence backwards and forwards on other legal issues which I don't have time to go into. So the law is relevant here. Don't think that the law does not matter. It is the tool. Without the law, without an ability to sort of cunningly use the law to further your own objectives, you would never get to this outcome. But also an involvement in the actual campaign, like any election, that was going on in the background here was the lobbying of shareholders. And, with the legal overlay of what you can and can't do, because what was critical here was once we were at 17%, close enough to 19.9%, any further lobbying of shareholders had to be done very carefully. What we couldn't do is get another shareholder to come out publicly and say, I've promised Michael I'm going to vote to support him, because that would be an association or give him actually a relevant interest in those shares, take him over 20%, he'd be in breach of the law. So we had to manage that.
But that's exactly what we wanted at the same time.
Well, correct, that's exactly what we wanted. So it was about going to see shareholders and, the script probably looked something like this. This is why we've requisitioned the meeting. These are my concerns with the company. I'm really wanting to know if you'd be inclined, based on this, to vote to support the resolutions that I'm putting forward. And they can say yes, they can say no. But you can't reach any sort of understanding or agreement with them. And as you can imagine, it's a very, very fine line.
What's your understanding of the rationale of that law, if it really is just driving negotiations and things underground, not making them very candid or frank as they perhaps should be?
No, the rationale, and it's a good rationale from a policy perspective, of the law. You can argue about whether or not the threshold should be 20%, which in other jurisdictions it's higher, it's 30%. But the point is, if shareholders, 2 or 3 shareholders, can get together and lock up control of a company before other shareholders have had an opportunity to be offered the same deal, right? The average shareholder, the minority shareholders, are going to suffer. So what it does is it stops a bidder coming and saying, I want to buy this company, going to, these 3 people saying, okay, I'm going to pay you guys a premium, or we're going to do some sort of deal. I've stitched up 40%. Now to the other shareholders, I'm going to make a takeover bid, but I'm not offering a premium for control because I've already got control. I've got control in my pocket already. I've got these guys locked up. So that's the rationale, and it's a good rationale. I mean, there is some debate that people say 20% is a bit too low. It should be 30%, but beyond that, it does make sense. And yeah, it does do a lot of this, but look, at the lower end of the market, this law is completely, it is just used and abused, right? At the smaller end of the market. And unfortunately, our regulators, maybe they will after the Royal Commission, but certainly historically, our regulators have not had the resources to pursue all the cases where associations have been breached. I sit on the takeovers panel and I see these very small, often mining companies, come to the panel with these association cases, and that's 1 out of 50 that come to the panel, and 1 out of 50 that actually go to the panel. The rest just nothing happens, and it's very, very difficult. But at the sophisticated, larger end of the market, where participants have quality and good advisors, they are acutely aware of these issues, and it does keep them honest. And as you can see in this case, it meant we had to take our case to all the shareholders instead of just stitching it up and doing some backroom deals with 40% of the register and then calling a meeting. So in that sense, I think it's good from a policy perspective. Now, this was very, very close when it came to the numbers. And, the target board, were very aggressive in how they approached some of the institutional shareholders for support. And ultimately, even when the meeting ended, we were sitting there in the EGM, what they did was it was a vote they did a poll, so you actually give in your proxies, so it's not just by a show of hands, and they didn't release the results immediately. They don't have to. They just said we have to wait till we've counted all the proxies that were voted at the meeting. So we left the meeting not knowing who won, waited a couple of hours, and we got a phone call from the chairman. And actually what won, it was literally neck and neck, and what turned it in our favour were all of the votes cast by employees. So employees, a lot of the employees had options, had shares, because they'd been with the company for a long time, and they were loyal to their CEO. And it's a very, very good lesson, again, going back to that point of hubris and arrogance, this was a board that, their strategy may have been right, who knows? Although the share price subsequently hit $1 at one point. Now it's come back down, but it hit $1 at one point. But they were completely disconnected with their shareholders, and they didn't think it appropriate to check with their shareholders before they terminated the long-standing CEO. And I think shareholders resented that because they are the owners of the company and the board wasn't. So it was successful. A new board was put in place. He was subsequently reinstated as the CEO. And the rest is history. But this is often used and looked at as a case study. And since then, there have been, quite a few similar sorts of matters. If it's not a CEO, it might just be a major shareholder. And Praemium is referred to as sort of a textbook case of often a board that is disconnected from its shareholder base, but also the power of a 4% shareholder. He owned 4% of the company, and he got rid of the entire board. Didn't have to buy or spend $1 buying another share to do so. And that fundamentally is where activism comes in and makes it very different to any other sort of corporate activity.
And I think, the other sort of learning from a law firm perspective in terms of a matter like this, I mean, a lot of what we do every day is we operate within the confines of relationships that we develop with clients. Certainly we need expertise, but, we need the clients to really trust us. Think about the trust and loyalty that Jeremy would have engendered by, acting for this sort of client in those circumstances. There simply wasn't a matter in the world that would have been more important to Michael, I can't pronounce his surname, Michael O'Hannison, than this one. And having delivered an outcome in relation to that matter, will mean that there is a sort of substantial reserve of trust to build on, to mutual benefit going forward.
So I think we've got some time for questions. We've got 10 minutes.
I think so.
Is there anything else? No. Was there others?
So we just put in a few, and I think we can circulate the slides subsequently. Yep. So we just put in a few other clippings from a couple of other matters, activist type matters, where we've been involved. So Ardent Leisure, I mentioned before, Dreamworld, and that's where we acted for Gary Weiss and Kevin Seymour, who actually bought quite a big stake. They bought 8 or 9%. And they didn't spill the whole board, but they did get several of their representatives on, and Gary Weiss became chairman.
And same things, Ardent share price has gone like that
Since. Shareholder Activism on the Rise, that's a cartoon of Alex Weislitz, and Jeremy sits on one of his boards. And I think that might be it, I don't know.
But if you're interested, you can go on our website, and there's a Shareholder Activism section. You can read a whole bunch of different matters we've been involved in. So, any questions, comments, thoughts?
Yeah.
So, do you think Australia's on a trend of mirroring sort of US style hedge fund activism, or are we still quite reserved in how activity takes place? And if so, if Australia is mirroring the US and in the future, should we implement sort of US interest back section 13 filings, or are they like different? Are we translating different jurisdictions from Australia?
Yeah, it's funny. Jeremy and I, together with some lawyers from partners at Kirkland & Ellis, a big sort of global US-based law firm, and UBS. So we had a week full of client forums talking about shareholder activism just a few weeks ago. And that was a big topic of discussion. I don't really know. My instinct says that we are heading in that direction. There are a lot of things about the Australian market that are different to the US. But we have a big market, we have a very developed market. There are certain features of our legal system, like the 2 strikes rule that we put up on the board before, that really make the environment pretty favourable for activists, that would suggest we're going there. I mean, culturally, the activists, if you're reading the papers, the activists have made large plays in South Korea, in Japan in recent months. So you would have thought that in terms of the sort of general cultural makeup in those markets, it would have been a whole lot less favourable for activists. And yet the big US hedge funds have gone into those markets. They've changed their tactics, but they've gone into those markets looking to really exploit the same type of activist plays.
Just the other point that's worth making in relation to that question is that the fact is that the regulatory environment here is far more friendlier to an activist than in the United States. In the United States, the board just tell them to get stuffed. Here we've got 2 strikes, we've got a much easier capacity to call a meeting. We have all these sort of cases that we spoke about, and in America it gives far more power to the boards. They also don't have the same incestuous obsession with independent non-executive directors in the States that we have here, and that, you know, which is a factor about leverage and pressure. There was another question next. Yep.
Thanks. So just on the question of dealing with the clients, obviously this is a case where the client came to you and you would have thought, yes, it does look like the shareholders will support this guy because he's been with the company for so long, he was the founder. Would it have changed if you sort of personally were inclined to think that, no, this guy's just a bit crazy, I don't think he's going to win? How would you have done it differently?
Okay, so the truth is it wasn't that obvious at the beginning because, you know, he'd just been sacked, you know, there were some criticisms of him in the market, it wasn't so simple. But it's a good question. If you look at Maya, for example, which we're involved in, acting for Premier Investments and Solomon Lew in effectively trying to, you know, remove the chairman of Maya, which has been playing out in the press for 2 years now. That is, and it's actually a really important question because often the stated aims of the activist are not necessarily what their real underlying objective is. They might say they want to expel the board, but what they're really saying is they want the board to undertake a certain transaction. They might say they want a board seat, but really they want them to remove the CEO. So the answer is that, would it have changed the strategy? Yes, maybe we would have gone, when you don't have any sense of confidence that you've got the numbers when it comes to a vote, you've got to play a lot harder on the sort of legal pressure that you can impose, the reputational pressure on the directors, because then the prospect for the directors of a sustained ongoing campaign that's going to destabilise the company, impact its performance, distract management, and often an activist is very happy for the value of the company to deteriorate at the beginning because it proves their point and helps them garner support from other shareholders. So there would have been more focus on the legal pressure, reputational pressure, had we sort of thought that the numbers were a long shot.
But you might have changed your ask too. I mean,
Yes.
you were asking, they were asking to spill the entire board
Correct.
and appoint a whole new slate. If you don't have the numbers, then you might shift your ask. You might make it appoint
Just
one
the chairman.
person back onto the board,
Or
or
just
just
remove
get
the
rid of
chairman.
one. Yeah.
Yep.
Aside from the legislative standards and the media element of the strategy code, how useful is soft corporate law, so things like the ASX corporate governance standards, as part of the strategy used for shareholder activism?
So, talking about the ASX corporate governance standards. So the ASX corporate governance standards generally are an if not, why not system. So what they require is they require you to report against a series of standards that that the ASX has determined in consultation with the market, and report that on an annual basis. So the simple answer to your question is it's very helpful because you look through that reporting, you look for all the places where they have not complied, and those can be the hooks that you use in order to generate the leverage and generate the pressure on the board to suggest that change is necessary.
And a classic example of that right now, and that I'm involved in at the moment, is I'm acting for John Kirby, one of the members of the Kirby family, with the founders of Village Roadshow. They own, Village is now a listed company, but together with a brother who he's at war with and somebody else, they own about 40% of the company. And he is launching an activist campaign effectively to encourage, he's on the board, so he's currently on the board, which creates all sorts of other director duties issues for him. But he is very publicly launching a campaign to pressure the company to divest assets, improve shareholder value. They own all theme parks. They're actually a competitor to Ardent. And one of his primary complaints is that the chairman of Village is his brother, Robert. The CEO was the other major shareholder who just stepped down and announced that the company was undertaking a search for a new CEO, and the preferred candidate is Clark Kirby, the chairman's son. So if Clark is ultimately appointed the new CEO, you'll have a CEO who will be reporting to his father as chairman in a listed company, right, that owns iconic Australian assets, like village cinemas, all these the movie world, all those theme parks. In an environment post-Royal Commission where there's a focus on governance. He's in part of that campaign. We've been using the ASEC corporate governance principles as a very powerful tool. Exactly the point that you asked. So it absolutely can be a useful tool. But you're not going to get the ASX to really intervene on something like that. Yeah. I think we've got time for maybe one more question, if there's anything. Yeah. Over there.
Talked about planning and competition and consumer law being the major areas that have emerged in the past, 10, 20 years.
It was just that one person, but yeah.
Well, what do you see
Because I know nothing
next?
about those things. But
Of course. Well, what do you see the next areas of law that are being expanded or will expand in the next?
Shareholder activism, no. And by the way, shareholder activism is not all we do. But look, in my view, I think when you look at the environment, heightened regulatory environment that we're living in post Royal Commission, and this the way in which our companies are run with this non-executive director pool, anything to do with areas of directors' duties, corporate governance, where a director's liability is on the line. I mean, we're going to have now serious prosecutions of senior bank executives who in all likelihood go to jail. So if you're asking me what's the next hot one, that would be it.
Thanks.
Okay, add my thanks as well on behalf of the faculty. I think that was a really great and engaging session, and all the inside views that you got. So we're looking forward to the next few, So if you still have time to hang around a little bit longer, so that we'll mingle outside.
We'll be around, happy to chat.
And yeah, looking forward to seeing you to the next of these sessions.
thank you.